everyone, and welcome to another episode of Evershed Sutherland podcast, Global Guide to Freezing Orders. This is Rebecca Copley here, Head of Litigation and Dispute Management in the Middle East for Evershed Sutherland, and I'm based in the Dubai office. Today I'm joined by two of my colleagues, Shalagh Massingham, Partner, and Shibani Kapur, Senior Associate in the team. Now, some of our listeners may already be familiar with Global Guide to Freezing Orders, a podcast produced across Evershed Sutherland global offices. Today, we are summarising everything you need to know about freezing orders in the UAE. This is a particularly hot topic for the region in the wake of the increased number of businesses and high net worth individuals relocating to the region. This influx of capital has made the ability to secure assets and enforce all the more critical. So I think we should start by saying that the UAE is unique in having not one, but at least three jurisdictions. Shibani, could you start us off by explaining a little bit about each and why it's important to establish which jurisdiction we're talking about?
Absolutely. In the context of potential court action, the UAE comprises three main jurisdictions, what we refer to as onshore UAE, and the two main financial free zones, the Dubai International Financial Centre, or the DIFC in Dubai, and the Abu Dhabi Global Market, or the ADGM in Abu Dhabi. Each operate under different legal frameworks. So in the onshore UAE, the courts follow a civil law system, whereas both the DIFC and ADGM courts operate under a common law system. In the ADGM, the common law of England and Wales and the principles of equity are directly applicable. The ADGM's legislation is a mixture of some modified English laws and the ADGM's own legislation. The DIFC has its own legislation. It's therefore critical to identify the jurisdiction relevant to your client because the legal procedures and remedies available can vary significantly.
Let's dive into each jurisdiction then. I'll start us off with the process in the onshore courts. So, freezing orders are available through precautionary attachments under UAE procedural law, and whilst they achieve a similar result, they do operate slightly differently to how common law lawyers would expect. So starting with the process, it requires an application for a precautionary attachment to be made to the Court of Merits directly, that's where proceedings are already underway, or the judge of the Urgent Matters Court. The application should be reasoned and accompanied by supporting evidence. Moreover, the applicant may be ordered to provide information about the relevant property or assets which are or may be the subject of the application, including their location. The application is usually heard on an ex parte basis within 48 hours, and once ordered, the defendant's given notice and the applicant must, within 8 days of any decision, file its substantive case and provide evidence of having done that. Applications are governed by the UAE Civil Procedure Law. Article 247 sets out the relevant legal test. It allows for a precautionary attachment if the applicant believes the debtor's assets may be lost. The test can be met in circumstances where, for example, the debtor does not have a permanent residence in the UAE or is considered a flight risk or likely to remove or conceal assets. In practice, demonstrating a strong case on the merits of the substantive case is often critical in these applications. Shalagh, over to you. Could you tell us about the DIFC and briefly the process in obtaining a freezing order?
Yeah, of course. So as Shibani mentioned, the DIFC operates under a common law system, and generally speaking, freezing orders are available as an interim remedy to prevent the removal or dealing or dissipation of assets. Unsurprisingly, DIFC is a jurisdiction which is heavily influenced by English law principles, and as a result, there are a variety of different tests you have to go through when looking at a freezing order. The first is establishing a good arguable case and showing that the defendant actually the respondent has assets which can satisfy a judgment, and also demonstrating that there's a real risk that such assets might be dissipated or disposed of in some unsavoury way. And then last but not least, it must be a just and convenient to grant the order in such circumstances. And just by way of procedure, the process generally involves submitting an application to the DIFC court, or in the case of an ongoing prospective proceeding, filing a Part 8 claim, supported by an affidavit and a draft order. And it's important to remember the applicant owes the court a duty of full and frank disclosure at all times when applications are made without notice. And that's relevant because listeners really need to note that affidavits have got to contain all material facts and must be served as soon as reasonably practicable, in any event 3 days before the hearing. And they also need to explain why they're being served without notice as well. So you'd have to put that all down, being full and frank and transparent.
Great, thanks, Shayla. Shibani, what about the ADGM? How does the process compare to the DIFC?
Thanks, Rebecca. So similar to the DIFC, the English law principles for obtaining a freezing order also apply in the ADGM. The applicable legal tests and process follows a similar one to the one just outlined by Shayla.
Perfect. Okay, so let's move on to third parties. A question often asked is, can a freezing order or a precautionary attachment, if onshore, be sought against third parties? Well, the short answer onshore is yes, but any receivables owed to the debtor, which are under the control of or owed by third parties, do need to be specifically requested as part of the application. Shibani, Shayla, how about the ADGM and the DIFC?
Yes, so a third party to the underlying proceedings or the prospective proceedings may be a party to a freezing order where there is a good reason to support that its assets are in fact the assets of the defendant in the underlying litigation, or it will be available to the defendant to meet a judgment or award.
Yeah, and that's actually also the case with the DIFC. And just to add, there's a potential that a third party notified of an order can also be held liable if they knowingly help or permit a respondent to breach the terms of that order. So that's just really important to bear that in mind.
Right. So now considering the end game, does the applicant have to provide any form of security or commit to compensation if its claim is ultimately unsuccessful in the DIFC and ADGM?
Yes, so unless the court orders otherwise, the order has to include an undertaking by the applicant to pay any damages sustained by the respondent, which the court considers the applicant should pay. The court may also order the applicant to provide security, which can include a payment into court or a bond issued by an insurance company, for example, or a first demand guarantee or standby credit issued by a bank.
Yeah, and exactly sort of similar situation in the DIFC. So the court can consider whether it requires an undertaking by the applicant to compensate a third party other than the respondent for losses which are suffered as a result of any freezing order.
Excellent points, thanks both. In contrast, precautionary attachments are very much awarded at the judge's discretion. So the onshore courts can, at their discretion, require the applicant to provide a bank guarantee, a letter of indemnity, or other security before granting the order. More often than not, applications for precautionary attachments will run in parallel to interim orders seeking a travel ban against the respondent. So that's something also to bear in mind. Now, in a podcast like this one that focuses on a cross-border perspective of litigation, I think it's important that we address enforcement overseas and freezing orders made in support of proceedings abroad. So first, I wonder, can a DIFC or ADGM freezing order be made in support of substantive proceedings abroad, including arbitration proceedings?
Yes, so with regards to the ADGM regulations do allow for freezing orders to be granted in support of foreign proceedings, but the applicant has to specify the basis of the jurisdiction of the ADGM courts first. There are often two ways in which this is likely to be the case. For example, if the respondent is within the ADGM, or if the applicant relies on regulations 16.2 and 41 of the ADGM Court Civil Evidence Judgments, Enforcements and Judicial Appointments regulations, which outline the general jurisdiction of the ADGM Court of First Instance and empower the ADGM courts to issue injunctions respectively. We saw this authority referenced in a worldwide freezing order judgment in the ADGM recently involving ADCB Bank and Mr. Shetty, but as far as we are aware, it has not been tested in the way that the DIFC's jurisdiction has been, which Shayla is now going to address.
Okay, so turning to the DIFC has been on somewhat of a journey in this regard. So as a general principle, the DIFC courts do support freezing orders which are granted in support of ongoing foreign proceedings, and that includes the onshore Dubai courts. But like I said, they have been on somewhat of a journey, There was a decision in 2023 known as the Sandra Holdings judgment, which required a jurisdictional gateway to be established for an interim remedy to be granted in the context of foreign proceedings. However, only recently, in the much discussed Carmen judgment, the DIFC actually done a bit of a U-turn and decided it taken a wrong turning in the Sandra case. Obviously, as an international court, it's now held it's appropriate that Article 24 of the DIFC law should be used to give effect to what's known as the enforcement principle. So, in other words, parties who may ultimately be seeking to recognise and enforce foreign judgments in the DIFC are to be given the relief needed to protect the dissipation of the relevant assets. So we're actually back to where we were pre-Sandra Holdings.
That's a really important development for the UAE legal community, and so interesting to see the DIFC courts responding so pragmatically to request to overrule one of its own previous decisions. So moving on to the onshore courts, a precautionary attachment application can be made provided evidence of these proceedings covering a substantive claim is submitted to the court within the 8 days I mentioned earlier. Note that the debtor can always appeal the decision though. So now let's touch briefly on enforcement. Shalagh, can foreign orders be enforced in the DIFC?
Yes, they can. It will typically require the applicant to seek permission of the DIFC courts and follow various rules regarding recognition and enforcement in the DIFC. And vice versa, a DIFC court freezing order will be subject to the laws regarding recognition and enforcement in the relevant jurisdiction. And as matters stand, unless there's a treaty in place which provides otherwise, it's generally understood that only foreign judgments for debts or definite sums of money can be enforced. So where a foreign court has granted a freezing injunction, the DIFC court could rely on this to decide whether to grant an injunction, but a fresh action's likely to be necessary.
What about the ADGM, Shibani? I guess enforcement of a freezing order outside of the ADGM will also depend on the relevant recognition and enforcement laws.
That's right, Rebecca. And in principle, enforcement of foreign orders is also provided for under the ADGM regulations. That said, some provisions suggest that, like in the DIFC, this would be limited to enforcing monetary judgments only. So a fresh action may be required, with the order from the foreign jurisdiction being of persuasive value in any such proceedings.
That's a good point, Shibani. I think all three jurisdictions are aligned on this one and don't automatically recognise foreign worldwide freezing orders. So applicants have to follow the rules of recognition and enforcement in the UAE and reciprocity principles to enforce a freezing order from overseas jurisdictions before the onshore courts. Those would include satisfying the court that the overseas judgment is final and doesn't conflict with a judgment or order already made in the UAE, or with UAE morals or public order, amongst other things. To date, we're not aware of a foreign worldwide freezing order being recognised and enforced in the onshore courts, but who knows what's around the corner. So before we wrap up, what happens next once an order is granted?
Well, turning to the ADGM, the respondent must be served the freezing order if the application was made at a hearing without notice, and third parties impacted by the order, such as banks, must be notified. In that case, there would be a further hearing known as the return date hearing, and the respondent or third parties may apply to vary or discharge the order. At this point, the original order will usually either be set aside, extended, or replaced with a court-sanctioned undertaking, which has broadly the same effect as a freezing order until trial.
And it's pretty much the same in the DIFC, so everything that Shibani's just highlighted would apply in the DIFC as well.
Really interesting, thanks both. The process is very much court-driven onshore, which is certainly useful in the UAE, where obtaining information can be challenging due to less publicly available data and strict confidentiality laws. Once an attachment is granted, the court will liaise with the various governmental bodies to direct its attachment by sending order letters to the UAE Central Bank, for example. Listeners will, of course, remember the 8-day rule, which I've mentioned a couple of times now, requiring evidence of a substantive case to be filed, failing which the attachment can be lifted. In the event a positive substantive judgment is subsequently obtained, the judgment creditor must then file enforcement proceedings within 30 days of the judgment becoming final, failing which any attachment placed over the debtor's asset would become void. So, last but not least, the subject of costs and breaches. Shayla, who bears the cost of these applications and what are the consequences of breach in the DIFC?
Always the burning question. So generally, the principles are the same in the ADGM and the DIFC, and the judge will typically decide on costs at a second hearing in respect of a freezing order. The consequences, one of the important points to really mention is consequences of breach are really serious, and a breaching person could be held in contempt of court, which has certain implications with it. It could result in a fine, the seizure of assets, or rather seriously open up potential prosecution or, dare I say, imprisonment.
Thank you. Onshore, whilst breaching a precautionary attachment does not attract a legal notice such as contempt of court, if an individual intentionally interferes with the legal process involving a seized property by transferring, hiding or changing it, they could still face up to 2 years in prison and a fine of up to 100,000 dirhams, so still very serious. I also want to highlight an important distinction regarding costs in the onshore courts. The applicant must cover the court fees when making the initial application. If they win the substantive claim, the court might order that these costs be reimbursed by the debtor. However, any legal representation costs are not recoverable. So unlike in the ADGM and the DIFC, where ultimately the winning party is awarded usually the majority of its legal costs by the losing party, that principle does not apply onshore. So I think we've provided a good whistle-stop tour of the intricacies of freezing orders in the UAE and covered quite a lot of ground for our listeners to keep in mind.
Yeah, absolutely, Rebecca. And I think the best piece of advice we can really give is to the listeners is to come and reach out to us if they ever need any help in obtaining or defending freezing orders or precautionary attachments. I mean, we're ideally placed to help with 70 offices across 30 different countries. So finding support in the relevant jurisdiction should be the easier bit. So yes, that's always just a point to bear in mind.
Indeed. All right, I think that's everything. Thank you to all for listening and goodbye from us.